Okay, well, good afternoon, everyone, and thank you for joining us today. You are joining us in great numbers, which is lovely to see, although I think that means we're probably all a bit concerned about what all of this new legislation means for us. And that's our intention today, to go through the key aspects of it and try to work out what we need to do and when. Um, so before we do that, a couple of introductory bits of information. First of all, I know many of you. I'm Ed, but for those that don't know me, I'm Ed Hussey. I lead the People Solutions team here at Menzies. We provide outsourced HR services to clients. And I'm joined today by the rest of the team, being Willorna Brock, Chris Smiles, Sandra Sue, and Elena DiMaggio. Some of us will be speaking around some of the topics for today, and others are working in the background to marshal any questions that you want answered and to make sure that the technology hangs together. So they've got the trickiest job for the day, I think. Let's just have a quick look at the agenda. So there are two main topics we're going to cover today. The first we're going to do is the Employment Rights Bill. So although the topics in there are ones that aren't quite with us today, so we've got more time around that, we're going to cover that first because the second topic is preventing sexual harassment, and that is live and current. So actually it's going to be a more substantive topic for discussion today. So we're going to do that last so we can spend the time on it that we need. We're going to have questions after each of those main topics. So if you have questions, we're going to deal with them at the end of each section. So if you could please put them in the Q&A. I hope everyone can see a Q&A button. Please put your questions in there. We will get to as many of them as we can. If you've not got a Q&A button, or if you've got any other issues as we go through, then please use the chat function. And Sandra and Elena will be monitoring that and trying to answer questions about any sort of technicalities. But questions for the panel, if you could use the Q&A function, that would be great. We are recording the session, as you will have seen when you joined in, so it will be available. We are going to send you a link to the recording and a copy of the slides after the event. So that's all good. And of course, we're happy to follow up on any topics afterwards as well. So with that all said, I think we'll move on to the first main topic of the day, and I am going to hand that over to Chris.
Thanks, Ed. Hi, everyone. Yeah, as Ed said, I'm going to talk about the new Employment Rights Bill. It promises a lot of change in order, as the government says, to make work pay. And the points we're going to cover in this section are rights to family leave, extended flexible working rights, SSP changes, unfair dismissal and statutory probationary periods, how they're going to potentially work, and the much heralded removal of 0 hours contracts. So to start with, paternity leave. Historically, there was a requirement for 26 weeks service before an employee could claim paternity leave and pay. This requirement is being removed, and paternity leave and pay will be available as a day one right. Unpaid parental leave will also become a day one right, whereas previously parents needed to have 1 year's service to qualify. Additionally, there is the introduction of the day one right to at least 1 week of bereavement leave for employees, whereas previously there was actually no statutory entitlement. The next change included in the Employment Rights Bill relates to statutory sick pay. So currently there's a 3-day waiting period where no statutory payment is due to the employee while they're off sick, with payments only beginning from day 4 onwards. Under the new legislation, it's proposed that payments start from day 1 of sickness. So for those in companies who enhance statutory sickness payments, it won't have a big impact. However, those who only commit to statutory pay will now need to pay SSP from day one of the absence. It's also proposed to remove the low earnings limit, which is where an employee must earn an average of £123 a week to qualify for SSP. Although it remains to be seen what any new threshold will be, as this is part of the consultation that is currently being carried out by the government, it's likely to be a percentage of earnings instead. Now we move on to flexible working. As you will know, legislation was introduced earlier this year, making the right to request flexible working a day one right and increasing the number of requests allowed to 2 in a 12-month period. This legislation will be strengthened to make the granting of these requests the default position. Any request can only be refused if one of the 8 business reasons apply, and it is reasonable to refuse on that basis. The employee is also entitled to a full explanation in writing of any refusal and the reasons for that decision. Next is the day one right to make a claim for unfair dismissal. Now, this is definitely one of the proposed changes that's got everyone talking. Currently, there is a qualifying period for an employee to make a claim for unfair dismissal, which is 2 years service. This makes it relatively low risk to simply dismiss an employee with less than 2 years service should the need arise. Under the Employment Rights Bill, that qualifying period of 2 years will be removed and give employees the right to claim for unfair dismissal from day one. This, of course, provides protection to employees from unscrupulous employers, but will make it more difficult to part ways with a poor performing employee in the earlier stages of employment. However, it is proposed that there will be a fair and proportionate process introduced for dismissals to be carried out during the probation period. And this brings me on to my next point. It's proposed to introduce statutory probationary periods or qualifying periods, during which there will be a modified light touch dismissal procedure in place. Now, the length of this statutory period is likely to be up to 9 months, but do note this will include any extension to probation as well. What that process will look like is still under consultation. So therefore, employers would do well to ensure close management of the recruitment process to ensure that candidates being hired are a good fit. This is the best way to reduce the need to go through a disciplinary and dismissal process in the future. This could include a more rigorous interview process, potentially with additional interviews and skills testing. From a practical perspective, it will be very important to ensure that probation periods are clearly set out in employment contracts, and that more importantly, reviews are carried out regularly throughout the period and any issues dealt with promptly and decisively while the light touch dismissal procedure can be utilised. Not doing so will mean any future issues will need to be subject to a full disciplinary process to reach the point of potential dismissal. It is worth noting, however, that the government has indicated that the introduction of a new statutory probationary period and the removal of the unfair dismissal qualifying period won't happen until autumn 2026 at the earliest. Now we come to the other topic which has made headlines, 0 hours contracts. Contrary to most headlines, there is not proposed to be an outright ban on 0 hours contracts. Rather, that there will be a requirement for employers to offer guaranteed hours where an employee or worker has a regular pattern of work or a regular number of hours per week. Essentially, 0 hours contracts will only exist where the working arrangement really is ad hoc, and that can be clearly demonstrated. Where an employee is entitled to guaranteed hours, employers will also be required to provide a contract which reflects those hours. Now, the length of the reference period for deciding if hours or work patterns are regular will be set out in the coming regulations. And yep, you've guessed it, it's still under consultation. It's also been confirmed that employees will have a right to reasonable notice of changes to shifts or working hours and compensation that is proportionate to the notice given for any shifts cancelled or curtailed. From a practical perspective, if you have employees on 0 hours contracts, now would be a really good time to review what the hours actually look like in practice. Are they in reality working a number of regular hours each week or a regular pattern of hours? If this is the case, now is the time to reconsider what their contractual arrangements are and whether any changes are needed. So that is a brief overview of some of the main changes proposed under the bill. Nothing is going to happen soon. As I said earlier, the changes to unfair dismissal and statutory probation periods are unlikely to become law until autumn 26. The other points covered today as we speak are all still under consultation. And while those consultations are due to end shortly, there are many more stages before the changes become law. However, this does offer an opportunity to review and tighten up your current practices in terms of recruitment, induction, and performance management, as well as your contractual arrangements. By doing so, you can be one step ahead when more is published in the coming months. Of course, we can help with any preparations, such as carrying out document reviews or discussing your performance management process. And rest assured, we'll be keeping on top of developments and bringing you further updates as and when they are made available. Sandra, do we have any questions on those changes at this point that we can answer?
Yes, we do, Chris. Hello, everyone. We have had a question around flexible working. So the question is, what is the definition of flexible working? And does it mean that someone could accept a full-time job and then on day one request to work fewer days?
Yeah, essentially the answer is yes. I know people aren't going to like to hear that, but yeah, I mean, essentially someone could rock up on day one or day two and put in a flexible working request. That's just how the legislation works. What I would say is the strengthening of the legislation won't come in until later, and at the moment it's a right to request. It doesn't mean you have not a right to a flexible working pattern. We'd always caution making sure you've got a really good reason to say no if that's what you decide to do. But yeah, essentially, yeah, if somebody took a full-time role and then decided they didn't want to work full-time, they can make a request to work less hours. You know, that's there for the protection of the employee to an extent. You know, it allows them, if their personal circumstances change, it might allow them to retain their role. But I know for employers that's quite difficult. But yeah, essentially that's what they can do. Anybody else on the panel want to jump in on that one?
Yeah, I mean it's a very good question, and obviously with the introduction of day one rights in these areas, it's a natural question. I mean, one hopes the basis on which you've hired a job is full time, then it's likely that on day two of that job, your ability to be flexible, it would be recognized, is going to naturally be limited. But nevertheless, you will, as Chris said, you'll still have to respond the same way.
Yeah.
In terms of the definition of flexible working, I haven't got the technical definition to hand, but definitely the example you've mentioned is one. You know, it's where people you know, suggest working different hours or a different pattern or or reduced hours or all of those kind of things. Obviously, we're relying on more guidance coming out around these changes as the consultations carry on, and after that, frankly, we'll then be relying on case law as cases go through the courts. That's how it always works in terms of being able to finally work out what the parameters of this are. But yes, I mean, we are going to be faced with scenarios like that, I'm afraid. Anything else, Sandra, on these topics?
So we do have quite a few questions coming through. What evidence can be requested as proof of sickness?
Well, I mean, classically, I assume this is in relation to the SSP question. I mean, everybody should have something in their contracts that require people to self-certify their sickness in the first 7 days and then require a fit note from a doctor thereafter. So what I would say, and my colleagues may have another comment on that, is use your self-certification process. because what you are at least doing there is getting people to certify, obviously, that they were sick for this reason. And if it turns out in the future that that may not have been genuine, then obviously that's one of the purposes of self-certification, is that you've got that.
Yeah, there's no indication that they're going to change the parameters around self-certification and fit notes. That will still be self-cert for the first 7 days and fit note beyond that. I think if they tried to start getting people to get fit notes for day 1 of sickness, I think the NHS would fall over. So that doesn't look like it's going to change. It's just the change is going to be when the SSP payments kick in.
What they are talking about, though, is making fit notes more helpful, which, when we could have a whole webinar on that topic. It would be lovely if doctors would be more specific and practical and objective on those fit notes, but you know, watch this space.
I can just add to that question about sickness, about asking people to self-certify. It should be clear on your sickness absence policy what people are expected to do in terms of reporting sickness and providing evidence of sickness as well.
Good points. And I think a lot of the issues we're discussing today are going to be about reviewing policies, not just reviewing them, but ensuring that they're well communicated and that people understand them. Yeah, great point. Sandra, we can probably take one more at this point, and then we'll see.
Yeah, I was going to say one more question before we move on.
And then we'll save the others and see if we've got time at the end.
Perfect. So for whom is bereavement allowance available? For example, parents, siblings, grandparents, etc.
Thanks, Sandra. Yeah, I mean, that's a really good question. I mean, and actually the answer is we don't know what the legislation is to say in terms of that at the moment. I mean, where people, if sadly someone's lost a child, then that's covered by parental bereavement leave, which is already a statutory provision. Other bereavement leave, I would expect it to be immediate family. So yeah, as you say, parents, siblings, that kind of thing. But obviously, as we know, families these days don't look, you know, the traditional family is not something that's common these days. Families do look very different, and I think there will be probably some parameters put in, but I think some of it will be a case of you know, employers applying common sense and being sort of sympathetic to an individual's circumstances.
Yeah, I think there will be, I think you're right, immediate relatives, but with some complexity, obviously, as there always is. But we'll take that one away, and if there's anything in there that we can share right now, we'll put that in the follow-up email.
I expect that to come as part of come out as part of more detailed legislation when we get it.
Yeah. Okay, well, look, thanks for those questions, and when we come to the end, we'll see how many more we can fit in. But let's move on now to the next topic, which is the new duty to prevent sexual harassment. Now, sexual harassment has its own special status within discrimination law, and the previous government put in place this new duty. It's not a Labour policy, it's one that was already coming along. And it's a new duty for employers to protect workers from sexual harassment, and it was enacted at the end of October this year, so it's in force. Now, the preventative steps, which we're going to have a look at, that it requires are largely what you would have needed in place anyway to successfully defend yourself against a claim of sexual harassment, but it's now a positive duty that all employers take preventative measures, and there are some additional elements that have been added into that. But what we thought we'd do first is start at the beginning with a quick reminder about what harassment actually is, and then we'll build it from there. Harassment is a form of discrimination related to a protected characteristic, and you can see the protected characteristics that it covers there in the slide. Now, related to is interesting, because a victim of harassment does not need to have that protected characteristic, but the conduct that they are subjected to needs to be related to a protected characteristic. So, for example, it could be based on a mistaken belief that a victim is in a certain category that's protected, or they may be someone who is connected to someone who has that protected characteristic. So someone who has a disabled child, or who has a son who is gone through gender reassignment, something like that. So the protection covers a wide range of people. In terms of when it says worker, that includes people applying for jobs, employees, ex-employees, and people with the status of worker, so not full employees. So it has a broad application. And the legal test for harassment is when it's unwanted conduct that has the purpose or effect of either violating dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. So that's where unwanted means unwelcome or uninvited by the victim. So the harasser's intention is actually largely irrelevant. It's not about what the intention of the harasser was, but the way it was received, perceived, and by the people on the receiving end of it. And the employer carries the liability for an employee's behavior in these situations unless they can prove that they've taken all reasonable steps to prevent it. So that's why employers have been advised for many years to have prevention measures in place, although it has not been mandated in the way that it now is, specifically for sexual harassment. Final point to remember on the overview is, especially with Christmas coming, is that the workplace extends to anywhere connected with work. So Christmas parties, social events, anything that has a connection to work, and so that could include the online space as well. So there is that to consider also. So that's just a quick reminder of what unlawful harassment is. Let's just move on then and look at what sexual harassment is within that definition. So it's unwanted conduct of a sexual nature that has the purpose and effect of violating a person's dignity or creating that hostile, intimidating environment. Of a sexual nature, but does not need to be sexually motivated. And so that's where you get the, things that people classify as banter, they don't necessarily need to be sexually motivated, but if they're sexual in nature, that can still create that intimidating environment. And it doesn't have to be directed at anyone in particular. So it could be, behavior that goes on in an environment that some people will find offensive and degrading. Also, conduct that in the past someone may have invited or welcomed can become unwanted. And also, all harassment can be based on a single act. So it doesn't necessarily need to be some kind of endemic problem. And examples of sexual harassment are those that are on the slide now, which I won't go through in detail. Okay, so let's look at the positive duty then that now exists. Positive duty to prevent harassment. That's now been applied to this special category of sexual harassment. And the reasons for that are to help transform workplace cultures. That was the intention of it in this area. And that's because of very high incidence of sexual harassment against mostly women, and the equally high incidence of non-reporting of these issues. And obviously there's a constant stream of high profile cases, in the press of where this is happening in high profile areas. Now, the duty says you must take reasonable steps, which is being referred to as the preventative duty. And what is reasonable will vary for each employer. So there's no one size fits all. Every employer needs to judge what's reasonable for them, and that will depend on their size, their resources, their sector, you know, what particular risks there are in their particular environment. And the requirement is therefore for employers to anticipate scenarios and take action to prevent them, or if something's already happened, to act to prevent it from happening again and review your practices in terms of prevention at that point. The preventative duty is anticipatory and ongoing in the parlance. And there are specific obligations to identify and treat harassment of your workers by third parties just as seriously as if it's harassment by a fellow colleague. And this anticipatory and ongoing duty means basically you can't just tick the box now and put it in a drawer. It's got to be a dynamic process where you're regularly reviewing and you're doing reviews. If a claim, you know, has to be dealt with, you're then having another look, and it's a kind of a live process. For those, so yeah, and essentially what all of this means is, you know, without this standard tick box process, you essentially have to risk assess your own business, and identify actions appropriate to your situation. And actually the guidance we're going to refer to says, you know, you're not really going to meet the guidance unless you carry out your own risk assessment in your own business. We'll come on to that in a second. For those found not to have taken reasonable steps, if a claim is made against you for sexual harassment and succeeds, then the awards can be uplifted by up to 25%, and obviously discrimination awards are uncapped, so that could be 25% of quite a high number. And also the Equalities and Human Rights Commission are being given additional powers to actually take enforcement action. So it doesn't necessarily, your only risk isn't necessarily claims being made against you, but also EHRC can take enforcement action, can come and investigate your workplace if it has concerns. Now, although I've just said there's no one-size-fits-all approach to this, the EHRC, Equalities Human Rights Commission, has set out an 8-step guide for employers. And this is important because it's what the courts will use essentially to judge whether companies have met the requirements. And so that's therefore what we're going to just take a look at now as to where we need to focus our attention. And Willorna, over to you. Willorna's going to take us through those 8 steps.
Hi, good afternoon, everyone. So yes, the EHRC has provided some guidance on how to approach your risk assessment. It's an 8-step guide. You don't actually have to follow it in order, but these are all the things that you would need to consider when carrying out your risk assessment and managing an anti-sexual harassment environment. So with everything in HR, we always talk about policies. So the first step is to make sure that you develop an effective anti-harassment policy. This can be a standalone policy, or it could be part of a statement as part of your diversity and inclusion policy. And please also ensure that it's included in your disciplinary policy in terms of listing incidents of disciplinary sanctions and disciplinary rules. And then, of course, you need to engage staff. And the key things to note about engaging staff is to use the data that you already have at your disposal to inform your policy. So find out what's going on in your organization. In some organizations, there's so many hidden things that people don't know about, people don't talk about. So this is the time to have an open door policy where you could use regular catch-ups, one-to-ones, and information from your staff surveys or exit surveys to find out whether there are any sort of underlying issues. And you can also use that data to find out whether any sort of prevention steps that you have are working. And then once you've developed your policy, of course, you need to ensure that people are aware of these policies. The EHRC's guidance focuses on prevention. So if something goes wrong, if there's a case of harassment in your workplace or there's a claim, you will need to show what you've done as part of your prevention strategy for this to have not happened. So one good way of doing this is to include anti-harassment policies and training as part of mandatory induction training. So when people join your organization, they're made aware of your culture and your zero tolerance approach right from the start. And then assessing the risk and doing the risk. Now you need to consider incidents where sexual harassment is likely to occur. We've mentioned social events. For example, we're coming up to the festive season, lots of incidences where people might be drinking alcohol or under the influence of alcohol. Some female members of your team might need to travel alone or go home late after the event. So what can you do? The examples of companies who have actually put in Christmas events during the day to avoid people having to go home late. So think of incidences and things that you could do to prevent these incidents of sexual harassment occurring. And then reporting. Make sure that your employees are aware of how to report. So you need a reporting structure that allows people to make complaints on either a named or anonymous basis and makes clear what will happen with information that's provided. So whilst it's preferable for people to raise issues without anonymizing their details, some people will not feel able to raise their complaints and issues, and that will therefore go undetected. So try and make sure that you have a reporting structure that allows people to be open and give complainants information about the support that will be provided if they do raise an issue. And this helps you to take action to address the matter, even in cases where you don't have sufficient evidence to start an investigation because somebody has been anonymous. And also make sure that you're always reminding people of the policy and monitoring the team or the business that's affected after an incident. So make sure you have a good way of keeping records to identify trends. Next slide, please. Now we go on to training. Of course, all of this is really important in terms of making sure that people know what the law says about harassment. Some people might be new to the topic, so the training should cover what sexual harassment in the workplace looks like, what to do if they experience or witness it, how to handle any complaints of harassment, and this includes your reporting procedures, who to report to, how complaints will be handled, etc. In terms of complaint handling, you need to act quickly to resolve the complaint, taking into account how the person wants it to be resolved as well. So you'll be handling this complaint in conjunction with the person who made the complaint. There might be instances where people come up to you and say, report a complaint, but they don't want you to take any action. You could respect their wishes, but you still need to take steps to ensure that the matter is resolved. I mean, if it's a very serious matter, you may need to take action regardless of whether they want you to do it or not, because you will have to do it in the interest of them as well as the company. You might have a serious case that would bring reputational damage to the organization. There's one in the press right now. So remember to keep records, remember to provide support and guidance, keep people informed throughout the process, and communicate the outcome of the complaint and outline any appeals process to the complainant in a timely manner. Ed mentioned third-party harassment. So you are responsible for any sexual harassment incident that occurs to an employee by third-party stakeholders, external stakeholders, such as customers, clients, patients, or suppliers. An example is in a call center where an employee may receive an abusive phone call, or in a pub where they get, physical or verbal abuse. So guidance should be provided on recognizing harassment and what to do if they experience or witness it. Make sure that your supervisors and managers have additional guidance on what to do when they receive a complaint or a report of harassment. They need to be guided on investigating complaints, taking disciplinary action, and supporting people. You should keep records of who has received the training and ensure that it's refreshed at regular intervals. So it's not a one stage thing. It's not a one-off. It has to be constantly done and refreshed and looked at, because this is all what you're going to do to convince the HRC that you have taken that preventative duty quite seriously. And monitoring and evaluating the policies and your preventative actions. All the policies should be reviewed on a regular basis and monitored to see how effective they are. Usual good practice is to do this as part of your annual review of policies or following the evaluation of any incident that happened. Next slide, please. So how we can help. We've got our HR services team here, and I know that most of you will be thinking about risk assessment, how to carry out your risk assessment. We can help you with doing that. We can also help you with drafting and reviewing your policies. So we would advise that when you're looking at bringing in a new sexual harassment policy, you look at your whole sort of suite of policies as a whole, because sometimes these things are linked, especially linked to grievance and disciplinary policies, for an example, as an example. And then we'll also help you to support with training with managers and employees on rolling out the policies and the guidance that people need. And of course, if you have any incidents, any sort of complex employment relations issues relating to that, we can help you as well. We do stress on a proactive approach, not to wait until things go wrong to engage HR. Thank you for listening, and over to Ed now.
Thanks, Lorna. That was a great summary of the EHRC guide. And I think what we'll do in the follow-up email is to put the link in there for the EHRC guide. The 8-step guide is quite straightforward one, but it's important to recognize, I'm just referring to a quote here, is that, you know, whilst every organization has to do its own risk assessment and go through its own thought process, and therefore things might vary per organization, the EHRC does say that all employers must take action and no one is exempt. So there is an expectation that that this risk assessment process, because I think this is really the kind of one of the new aspects of it is, you know, how do I go through this risk assessment process for my business? What does it look like? Now, it might be that you have health and safety risk assessments. It's a similar process. It's a similar thought process, you know, similar format. You can use that type of approach, but that's really going to be something organizations will need to do. And the other thing the HRC guide says, it's unlikely you're going to be able to comply without doing that risk assessment. So that's a kind of a key message. Make sure if you have questions around that, pop them in the Q&A. Whilst you're doing that, we're just going to put up a poll, and the poll is asking you about what you'd like to understand more about. And this is just so that we can identify what the areas of particular interest are for people, and if there's any specific follow-ups that we might want to do for you. So whilst you're doing that, we could move on to questions. So Sandra, have we received any more?
So if we just start off with the sexual harassment questions, and then we'll come back to Chris's section. So the question that we have regarding sexual harassment is around the work events. So a single female on the train or in a taxi, for example, this would not be harassment by business stakeholders. So what are the requirements on the business here?
Very good question. Oh, look, there's the results of the poll. Just okay, so the unfair, yeah, not surprisingly, the unfair dismissal and statutory probation periods is going to be a massive topic, and we're definitely going to be giving that a lot of coverage in the run up to that. So yeah, totally understand that. And then preventing sexual harassment, yeah, and flexible working, yeah, interesting. And just to say, sorry, I will come back to the question. Just off the back of that poll, there are other things you might have seen in the news, but things like fire and rehire and relaxation of rules on trade unions. Those things are happening. They don't tend to apply very much to our client base, which is why we haven't covered them specifically here. But obviously, if they do apply to you, then please do get in touch and we'll be happy to talk to you about them. So just coming back to the question that you asked there, Sandra. Yes. So your requirement, so this is about the definition of a workplace, and the rule is if it's connected to work, so actually someone traveling to or from a work event that's sponsored by work, where drinks are being paid for by work, it's organized by work, that will meet the definition of a workplace for the purposes of harassment. And so you do have a duty to think about how you're going to protect people from sexual harassment in those circumstances. And so part of your risk assessment should just think about that, you know, and I think Walorna alluded to a live example we had last week where one organization has decided this year, having had a fairly difficult experience last year of what happened after a very late finishing Christmas party where there was a lot of alcohol taken and etc., that actually they have they're now doing their Christmas do during the afternoon. It starts with lunch and goes on until 4, and you know they'll provide some drink, and then it's very clear that after that, whatever people decide to go on and do in the evening, you know, the work event has finished, and that's going to be up to them. But I think for that person traveling on public transport, you know, think about it in your risk assessment in terms of work events, and are there practical measures that you can put in place just to help to prevent things. Now that might be about how you organize things, it might be about you know, sort of advice you give to people if they confront it. It could be all manner of different solutions, but go through that thought process is the recommendation that's in the guidance. Anyone else have anything to add to that? I don't want to hog the answers. Nope.
Okay, so the next question is, what happens if my head office and personnel department are based in Australia? Do I need to compile a sexual harassment policy according to UK laws?
Yeah, I can answer that.
Yeah.
So we have lots of clients who have parent companies abroad. With international HR, it's always down to the local legislation. You always have to comply with local legislation. So the answer to that question is yes. If you're operating in the UK, you will have, in England and Wales, you will have to put out policies that comply with our legislation.
Mm-hmm.
Yeah, I guess if you're operating in the UK, therefore you have a premises, you have employees, and you need to adhere to the legislation and provide that protection for them, no matter where the global HQ is.
Yeah.
Perfect.
Yep, quite right. Next.
Yep. So if I can go back to questions on like SSP and the pay. So one of the question was, if we hired someone and they go off sick within the first week of working, do we still have to pay SSP?
Yes, is the answer. Sorry, these questions are coming and the answer is yes, and I know people aren't going to like hearing it. Yeah, essentially they're entitled to SSP in the same way as all employees. There isn't a qualifying period for SSP. You know, some companies I know do enhance their sickness payments, and they have a policy around when that begins. So you might have a policy whereby you only pay SSP for the first 6 months until perhaps someone's completed their probation, at which point the enhancements would kick in. But SSP would always be due. And under the proposed new legislation, it will be due from day 1 of absence rather than day 4.
And that's a very good point about, you know, how you might design your company sick pay policy as opposed to what the statutory position is going to be. So yeah, you can, as Chris said, you could think about starting your company pay later, if that's something that you wanted to do. And obviously the law is being changed to protect people who are genuinely ill from day one, not for the people who aren't. And so what that does, as in many other of these areas we talked about, is throw the light onto, you know, your own internal processes and the way you manage persistent absence. I mean, there was a question about, you know, so someone who's, you know, where a questionable absence, which, you know, they have always happened, and you should track that person's record and manage that as an issue if it's a regular thing that that takes place. And well, Lorna's already mentioned, you know, having a good sickness absence policy and following it is how that gets managed. So yeah, it does, you know, we are going to need to sharpen our pencils in areas of, you know, HR management.
Absolutely, Ed. Yeah, I think you're right. Yeah, all these changes I've been talking about today, I mean, obviously we don't know all the detail yet, but they're all going to need to be mitigated with good policy, good management, good employee management. That's going to be really key to mitigating the impact that it's going to have on employers.
Yeah. I guess the law is there to protect employees, but obviously employers have, you know, their businesses to consider as well. You do have a business to run. I don't think the law is there to say, you know, you can't sack people, you can't dismiss people. It's usually about your policies and the environment. So usually tribunal claims will question you as to whether you have actually followed your own policy. Whilst the law has, you know, parameters, but you can set up how you want your organization to run within the parameters of employment legislation. So you can have a sick policy, you can have a performance management policy, so that people know from day one what to expect and what would happen if things go wrong.
I think the only follow-up to all of this I would make is that we appreciate, particularly for small and medium-sized employers, how potentially burdensome everything sounds at the moment. And yes, you know, obviously there's a lot more, you know, process and procedure being required. Our commitment is always to help to manage that in as pragmatic a way as possible. So, you know, helping people get from A to B whilst, you know, balancing their risk in a pragmatic way, in terms of, you know, identifying the key things that need to happen and also those things where there might be some, you know, some flexibility. So please, you know, talk to us about what you think the practical implications of this might be for you, and how you find your way through it. And that's what we're here to do. Do we have any more questions?
We do have one final question, which we kind of touched on already. What is to stop employees from phoning in sick just because they don't feel like coming into work?
Yeah, nothing.
Nothing.
And
That's always been the case, though.
Yeah,
that's always been the case. I think the
Yeah.
implication of the question is they might be even more motivated to do it now that they're going to get SSP
Yeah.
from day one.
Yeah.
And you more of a motivation, and that does therefore place that, you know, that burden back on to us employers to, you know, create the right environment, to have the right approach to things, to challenge people perhaps more readily than we did in the past when things don't look quite right.
I think it's also worth. Sorry, Ed.
That's right. Go for
I was going to say it's also worth mentioning that it's SSP now. For some employees who potentially are right at the lower end of the pay scale, they may not see much difference, but for a majority of employees, taking a day off sick will mean a reduction in wages. So it's not, It's not that you know, they're just going to be able to swan around and put their feet up for the day and still
Yeah.
bring home the same amount of money. I think SSP is you know, not big and not a big payment at all. So there is that aspect to think about.
That's a great point.
Yeah.
That you know, if this does only apply to SSP, I mean, if you have a company sick pay policy, then it's that's unaffected by this.
Yeah.
I think we've just had another one pop in, haven't we, Sandra?
Yes, something came through on the chat. So this person lives in Dublin, and they wanted to ask if the law applies to them as well.
No. I mean, it may, Ireland may have its own version of it. I don't know, but this particular law only applies in England and Wales. So, and Scotland, I think. But anyway, definitely not Ireland. But that doesn't mean to say that there isn't a similar law in Ireland. So please check. But of course, if you have employees over here, as Willorna said earlier, it will affect anyone who, if they're employed by the Irish company but are working in the UK, then it will affect them. Okay. Are we there? Is that it for questions, Sandra?
Yep, that was all.
Okay, good. Well, look, everyone, thanks very much for joining us today. Really appreciate you coming. As I mentioned earlier, we're going to send out an email with some links and to the recording and the EHRC guidance and the slides, etc., etc. Please do keep in touch with us about any follow-up questions you have from this. We will obviously be working with our clients to support them through the required actions, particularly in the short term with regard to the sexual harassment changes. You'll have noticed on the screen there, we have an employers community. Please join it. It's free. We put lots of information on there just to so that everything's in one place for you. But yeah, thanks for joining us today. We will let you know about the next webinar. I'm sure it won't be long, given all of the changes that are up and coming. But until then, have a great Christmas, and we'll see you soon.
Thanks, everyone.